All right. Good afternoon, everyone. Thank you all for being here. We are about to get going on the 5th public comment hearing in 22R-0557EG. I officially call the proceeding to order. Just want to confirm that our court reporter Tracy is on and ready to go. Tracy, I saw your name. I just want to make sure you're ready to go before I get started.
Good afternoon, Judge. I'm ready to go.
Thank you, Tracy. Appreciate it. Nice to have you here. Okay. We are on the record now in Colorado Public Utilities Commission's proceeding number 22R-0557EG. My name is Alenka Hahn, and I am the administrative law judge assigned to this proceeding. It is Friday, September 15th, 2023 at 1:30 p.m., the scheduled time for this hearing to begin. This matter comes on for a public comment hearing pursuant to decision number R23-0475-I, dated July 25th, 2023, which continued the public comment hearing that was held in this rulemaking proceeding on July 18th, 2023. I want to welcome all of you and thank each and every one of you for being here today to provide public comments. This is an important process and will hopefully make the rules that we end up with ones that are more workable for all of us involved. Before we get to the public comment portion, I do have a number of comments that I need to first make. I want to say that some of my comments commencing this proceeding are repetitive of comments that I've made at earlier public comment hearings. Those were held on February 27th, April 4th, May 15th, and July 18th, 2023. So to those of you who have already heard these opening statements, I apologize for being repetitive, but please understand that my comments are intended for the benefit of those that are new to this proceeding and this process, and are for the benefit of anyone who might be listening on our webcast live streamed. Okay, the purpose of this public comment hearing is to allow members of the public to provide comments regarding proposed modifications to the Commission's rules governing electric and gas service. This proceeding was initiated for the purpose of implementing Colorado House Bill 22-1018, that's 22-1018, which is now codified in the Colorado Revised Statutes at section 40-3-103.6, subsection 1. That provision instructed the Commission to commence a rulemaking proceeding to address the steps gas and electric utilities are to follow when disconnecting the service of a customer unable to pay their bill, and also to cover the timeline for reconnecting such customers. The Commission's proposed changes to the rules modify certain definitions in the rules. In particular, the Commission proposes to add definitions to the rules for the terms advanced metering infrastructure, emergency or safety event or circumstance, income qualified utility customer or low income customer, qualifying communication, and utility assistance information. Second, the modifications to the rules address steps utilities must follow in disconnecting or reconnecting a customer's gas or electric service. And third, the proposed changes to the rules that have been discussed thus far in prior public comment hearings anticipate the implementation of remote disconnections and reconnections, as well as a process for advising customers of these new procedures. A few preliminary matters I need to cover before I turn to the procedures we'll be following today. Consistent with Commission practice, we are webcasting this hearing and we have a court reporter taking down everything that's being said. Because we have a court reporter, I will ask that everyone speak only one at a time. Please speak slowly and clearly in order to ensure that we have a complete record. The chat function that is normally found in Zoom has been disabled for this hearing, so please do not try to make comments using that chat function. All right, so let me now cover how the public comment hearing will proceed. You may provide written or oral comments. Written and oral comments will be given the same weight. The Commission does not give any greater weight to oral or to written comments. And in fact, the Commission prefers written comments primarily because people tend to be clearer and or more persuasive in writing than when they present their comments orally. They can also be more easily reviewed at a later time. If you would prefer to submit written comments, there are 4 primary ways to submit them. Through the Commission's electronic filing system that can be found on the Commission's website, through the File a Complaint or Comment link that's on the Commission's website, by email, or through snail mail using the U.S. Postal Service. The PUC's website address is puc.colorado.gov. The Commission's email address and mailing address can be found on the Commission's website. To provide a written comment in any of these 4 ways, please be sure to include this proceeding number, which is 22R-0557EG. Again, if you write a written comment, we ask that you please include the proceeding number for this proceeding, which is 22R-0557EG. The Commission also accepts oral comments, and in addition to providing oral comments here today at the public comment hearing, you can leave the Commission a voicemail message with your oral comments at any time by calling 303-869-3490. Again, that's 303-869-3490. If you leave a voicemail message with your comments, please be sure to include this proceeding number, which is 22R-0557EG. Your voicemail message comments will be transcribed, and then the transcription will be placed in the record of this proceeding, and I will review them. Okay, if you are here to provide public comment today at the public comment hearing, I will now go over the steps for providing comments during the hearing. First, if you haven't already, please change your Zoom name to your first and last name. This is important for a clear record and will let us know who is speaking and will let me know on whom I should call to speak next. In addition, if you're here representing an organization or an entity, I'd ask that you please include that information with your Zoom identification so that I know with whom you are here. If you don't know how to change your Zoom identifier, you do that by hovering over the 3 dots next to your identification, your name, and then you can, a drop-down box will pop up. You can click on rename in the drop-down box, and then you can type in your full name and affiliation at that time. Next, I'm going to ask that you use the raise hand Zoom feature to signal if you wish to speak. To do so, click the reactions button and click raise your hand. Please leave your hand raised until you've been called on. If you no longer wish to speak, you may lower your hand. And if you don't know how to raise your hand at all, or use that feature, you may instead turn on your video to signal that you wish to speak. Because of that, I'm going to ask that everyone please remain on mute with your camera turned off until your name is called. And make sure you please mute your microphone when you are done speaking. That will ensure that we don't get feedback or multiple people speaking at the same time. Please ensure that when you are speaking and giving comments that you speak slowly and enunciate as well as possible. As I indicated, only one person may speak at a time, and I ask that no one speak over anyone else. This will help ensure that the court reporter can hear and understand your comments, and that way we can have an accurate and clean record of the proceeding. Also, if someone has covered all of the points that you intended to include in your comments, please feel free to, in your comments, just state that you agree with the points that were made by the other person. If anyone is participating in this hearing by phone, let me go over those procedures. You will need to dial *9 to use the raise hand Zoom feature. You have to please listen very carefully for your area code and the last 3 digits of your phone number. When you hear your number called, you will need to dial *6 to unmute yourself. When I call your name or phone number, please unmute and turn on your video if you have that capability. Begin your comments by stating your first and last name first. And when you are speaking, please remember, again, that we have a court reporter who's making a transcript of everything that's said, so speak clearly and slowly so that she can get everything down. And if you are speaking too quickly and she can't understand you, the court reporter may interrupt you and ask you to clarify or restate what you've stated. To those of you who are here today who do not wish to speak and are only here to observe, we are live streaming this hearing on our website. The link is in the bottom right corner, puc.colorado.gov/webcasts. When you go there, you will see we are in hearing room B, so click on that, and you'll be taken to the webcast of the hearing. We ask if you are not making comments today to please use the webcast to observe the hearing and leave the Zoom meeting, but you know that you are free to join back at any time if you decide you do wish to make comments. Okay, that's the conclusion of my opening statements and our precedent for how we proceed. So let us then turn to the public comment portion of this hearing. I'd like to turn to the issues then we need to address today. I want to state, first of all, that I continued the hearing at the end of the July 18th, 2023 public comment hearing to allow interested persons an opportunity to review proposed consensus rules that were filed jointly by several interested entities immediately prior to the July 18th hearing. The entities that filed that joint proposed consensus rules were the Energy Outreach Colorado, the Office of the Utility Consumer Advocate, Public Service Company of Colorado, and I believe also Black Hills Energy. Their proposed consensus rules were filed really just a few minutes before the scheduled time of the last public comment hearing, which did not provide interested persons or myself much time to review them before the hearing commenced. So I wanted to allow additional time for another public comment hearing after people have had a chance to review them, and to provide time to anyone who might be interested in providing written responses to the proposed consensus rules. I asked anyone interested to provide me with written responsive comments to the proposed consensus rule by August 11th of 2023. And on August 11th, Colorado Natural Gas, Inc. and Atmos Energy filed their joint comments responding to the proposed consensus rules. I hope we have representatives from those two entities here today, because I do have some questions about their comments that I would like them to address. Briefly, though, having carefully read those comments, as I understand the positions of Colorado Natural Gas and Atmos, they've objected to certain portions of the consensus rules to the extent that they'd be required to provide public outreach and notification to their customers, even though they don't employ remote disconnection and don't have plans to implement that technology soon. As I understand it, they argue that requiring utilities to notify customers about disconnection procedures, they argue it exceeds the scope of the initial rulemaking NOPR, the Notice of Public Rulemaking. And they contend that the proposed additional reporting requirements mandating that utilities advise the commission of their educational outreach plans and programs could be overly burdensome for them. Colorado Natural Gas and Atmos suggest certain changes to the proposed consensus rules, which may alleviate and address their concerns. Most notably, they're suggesting changing the word a utility to simply to narrow it so that it covers a utility employing remote disconnection technology. Okay, so with that preface, I'd like to start with a discussion of Atmos's and Colorado Natural Gas's comments to the newly filed proposed consensus rules. And I'd greatly appreciate hearing from Atmos and Colorado Natural Gas about their joint position. And then I'd like to hear from other entities how about the consensus rules and their perspective regarding Colorado Natural Gas's and Atmos's comments. Okay, first, I would like clarification on one point from Colorado Natural Gas and Atmos. In your responsive comments, in your joint comments, you focused on Rule 4407 of the gas rules. And I would like some clarification. Are you proposing then that changes you're suggesting limited to the gas rules alone, or would they also apply to the electric rules, which I think specifically the parallel one is Rule 3407? Mr. Stoffel, I saw you turn on your camera. If you could go ahead and answer that question.
Good afternoon. Happy to kick this off. So speaking for Atmos, I think they are indifferent as to the changes to electric rules because they do not apply to Atmos. And that was why these comments focus solely on the gas rules.
Do you have any objection to making them parallel? From my perspective, I think the rules are right now designed to be parallel. So I think it's less complicated from my perspective if we were going to make this a change to the gas rule that we also do it to the electric rule. Do you have any objection to doing that?
No objection to that, so long as it's limiting these requirements to utilities employing remote disconnection, which is why we thought is appropriate, especially to limit that in the gas rules. And for electric utilities, it sounds like they either are or are going to pursue remote disconnection in Colorado. And so you really want to make sure that's clear in the electric rules as well.
Okay. Thank you very much, Mr. Stoffel. Does anyone else have any response or comments in response to my question about the parallel nature of the rules between the gas and the electric rules? Anyone from Colorado Natural Gas? Mr. DiDomenico, go ahead. Please state your name and your affiliation for the record. And you're muted right now. There you go.
Hello, Your Honor. Harry DiDomenico with Colorado Natural Gas. I think we would just echo what Atmos said about including it. You know, we're just wanting to address gas utility rules.
Okay. So basically, Colorado Natural Gas doesn't care if it's in the electric rules, one way or the other. Okay. That's very helpful. I just wanted to make sure. I didn't know whether you objected to it or just were indifferent.
Thank you, Your Honor.
Thank you, Mr. DiDomenico. Appreciate it. Okay, let me ask then from the other utilities, on this one minor point, does anyone have any, if we were to adopt the changes proposed by Colorado Natural Gas and Atmos to the consensus rules, does anybody object or have a comment about paralleling them and mirroring them in the electric rules as well? Are there any electric utilities here? Mr. Bennett, please state your name and your affiliation.
Thank you. Andrew Bennett with Energy Outreach Colorado, VP of SC. Just from understanding, so you're saying, would we, as people signing on to consensus rules, agree to take the proposed language for Atmos and CNG, apply that to our consensus rules for both gas and electric?
Yes, that is exactly what I'm asking.
Okay, just wanted to verify. We'd be opposed to that. I think the consensus rules that we adopted in conjunction with the Utility Consumer Advocate, EOC, the other two utilities, which comprise of both gas and electric, that we would stand by the consensus rules that we adopted and came up with previously,
So
or that
you,
we came up with, sorry, rather.
so you object to saying, you wanted to say just a utility, not a utility that engages in disconnection, remote disconnection. That was the
Right,
only change.
Right, as I'm seeing it, that this change is in order to keep Atmos and CNG from having to do similar customer outreach and engagement as the other gas and electric utilities in the state.
What outreach would they be required to do though if they're not engaging in remote disconnection?
Well, that's what I was trying to clarify. Do you mean across the board? Because as I was reading in their comments, they do not want to do any of the similar customer outreach and engagement. So if we're throwing all of that out, that's where we would have concerns that they don't want to do any of the outreach for customers about disconnections, period.
Okay, I guess I'm a little bit confused then. Again, Mr. Stoffel, could you please clarify exactly the scope of Atmos's proposal?
I think your initial understanding was correct, that it's limiting the new requirements proposed in the consensus rules to utilities using remote disconnection. That's not opposing any outreach or education for other customers. It's going back to what is really the status quo, that education and outreach for customers on the gas systems that are facing disconnection is specific to those customers. It is notifications provided to those customers. It is door tags placed on those customers' premises, and all of that would continue. And so that's what we're saying essentially. While the new law imposes some different requirements around reconnection, with the exception if a same-day communicator, a qualified communication is provided, that otherwise business as usual continues for gas utilities that are not intending to adopt or employ remote disconnection. And so that's why we're saying, to the extent you adopt what's in the consensus rules, apply that only to utilities that are using remote disconnection.
And so if Atmos at some point were to implement remote disconnection, you would not be opposed to being subject to these outreach and educational requirements?
Correct.
Okay. Thank you, Mr. Stoffel. I appreciate that. Mr. Bennett, with that clarification, what is your position?
So I think even with that clarification, what we're still looking at is, as Mr. Stoffel said, is they want to maintain the status quo. In the consensus rules, we adopted additional language about what it is that you're going to be doing, your strategic planning and other things like that. So we would still want to see the same thing. Remember, Black Hills and XL are both gas utilities as well. So it'd be really weird where we would have the electric side, just by virtue of having remote disconnection, have to talk about their strategy around outreach and customer engagement. And yet the gas utilities would not be doing the same thing, when at the end of the day, the concern about disconnections, reconnections goes across the board, whether they're talking gas and electric. And that customer outreach engagement and having a plan around it is important on both sides. It's not just valuable only by virtue of having remote disconnections. So I think, if they're talking about they don't want to be beholden to a remote disconnection rule because they don't do that, that's one thing. But the additional language, that was very important for the utility consumer advocate, and Mr. Dixon's online if you'd like to speak about this. But that was something that was very important to them as they shifted their position about getting strategic reporting out of utilities. So I think so long as we're eliminating the additional rules, going to the status quo where the gas utilities have to make no changes, that's not something that EOC would be in support of, and I'd let the other joint respondents respond as well.
Okay. Thank you so much, Mr. Bennett. I appreciate it. Mr. DiDomenico, you've got your camera on. Would you like to go ahead and speak?
Yes, Your Honor. Our view on the outreach is that if we were to implement remote disconnect technology, we would have to file some filing with the commission anyway to institute that, either an advice letter or an application. In that, these other parties in this proceeding would have the opportunity to intervene and make recommendations as to what that reporting should be. We wouldn't be opposed to having that discussion at that time. We just think to put it in the rules now directed towards utilities that aren't even contemplating this type of activity. The existing rules as they stand already provide for outreach. Further, Rule 4412J requires us in the low income rules to meet with stakeholders annually. That is an opportunity for us to conduct the outreach they're discussing.
Okay. Thank you so much, Mr. DiDomenico. I appreciate that clarification. Mr. Dixon, you've got your camera on. Would you like to go ahead and speak?
Yes, this is Tom Dixon on behalf of the Utility Consumer Advocate. First of all, I'd like to say I have trouble hearing Mr. DiDomenico. I know if he can get closer to his microphone, that would be helpful. I would agree with what Andrew Bennett has just said. The gas utilities are trying to draw a bright line based on whether or not remote disconnections are occurring. The statute that was passed did not limit itself to remote disconnections. It is a broad statute that says if you disconnect, you must have a reconnection policy that's consistent with the statute. There is nothing that says it has to be a remote disconnection or otherwise. The statute recognized that something could be done remotely, but it didn't condition its requirements on whether or not the entity, the gas or electric utility, was indeed exercising remote or applying remote disconnection. So this bright line, which is very obvious and makes a great deal of, you can see it, has no relevance to what the statute was about. The statute was about generally reconnecting and disconnection policies, and they apply to all electric and gas utilities, regardless of how they disconnect their customers. And so I totally agree with Mr. Bennett. These rules should be identical effectively because, again, the process of disconnecting is applicable to gas and electric utilities. I don't dispute that Mr. Stoffel points out the utilities all do a lot of contact with customers in order to disconnect. In fact, Black Hills, I think, put in some evidence of their, I may be wrong, 9-step, but it may have been more or less process. That's not what we're talking about. We're talking about a customer education program that is broader than just, oh, if you're the one that's going to be disconnected, we're now going to have an amount of contact with you to describe what's going to happen. We're talking about providing customers notice, for example, clearly about what the new statute requires, which again is not just, a tariff filing. The fact of the matter is, customers, I would suspect, rarely even look at tariffs or know what tariffs are. What they look at is material that comes directly from the utility, either through emails, through telephone messages, through text messaging, again, if it's been approved, as we have talked about, or finally, just simply snail mail or U.S. mail, where they provide information to customers. As a customer, both Atmos and public service, I get emails, text messages, and I don't get any paper because I'm all electronic from those companies, and it's very helpful. And so that's what we're talking about. What gives the customer notice of the process, not telling the customer, here's what the process is now that we're about to disconnect you.
Thank you so much, Mr. Dixon. Appreciate it. Mr. Stoffel, you have your hand up. Would you like to speak again?
Yes, thank you. I just wanted to respond to something Mr. Dixon said, and it is not Atmos's position that they do not have to comply with what's in the new law. That is absolutely clear that the reconnection requirements and exceptions to those requirements apply to all utilities. What we're objecting to is the layering in on top of those requirements, this proposal around customer education and outreach strategy, a multi-year plan, ongoing reporting requirements, which really, as we understood as this proceeding evolved, were focused initially on remote disconnection. And then several rounds into this became applied to all, or proposed to be applied to all disconnection. So the right line we're proposing to draw is not relative to what the statute requires. It's relative to what is outside of the statute that was proposed in the consensus rules.
Got it. Thank you so much, Mr. Stoffel. Mr. Dixon, you turned your camera back on. Did you want to respond to Mr. Stoffel?
I didn't suggest they weren't going to comply with the statute. This has nothing to do with complying with the statute. This has to do with how do you educate your consumers about what the processes might be in the event they're in this situation. It's not wait until you're in it and we'll tell you all you need to do to avoid it. or to whatever. And so the point is the statute created new obligations. And I would suggest that most customers don't have a clue about what's either in the statute, tariffs, or even any material that's on the website of the utilities. It's when they actually get documents sent to them or have meetings as is proposed that they might have that opportunity. And to the extent that Mr. DiDomenico referred to the meeting that is for low income, obviously our customer education proposal in the consensus rules is not limited to low income. However, we did say we had no objection to having that annual meeting in conjunction with the existing rules. It was never our intent to ever have multiple meetings, one for low income and one for the rest of the customers. Our goal is to use one meeting, make it as broad as possible, and provide education to customers so they understand what the process might be in the event they found themselves in the situation of disconnection and how they could be reconnected immediately under the statute.
Got it. Thank you so much, Mr. Dixon. Does anyone else have any comments or discussion they'd like to have regarding the proposed inclusion of a change from a utility to a utility employing remote disconnection technology with respect to the consensus rule requirement about reporting to consumers? Anyone else have anything about that? Okay. Next, I wanted to address another comment made jointly by Atmos and Colorado Natural Gas in their joint comments in response to the consensus rules. In their joint comments, they also discussed qualifying communication, the definition of that, and referenced proposed rule 4407F. I've read Atmos's natural comment, but honestly, I'm a little unclear exactly what the position is and what objection is. So I would ask from someone at Atmos and somebody at Colorado Natural Gas to please explain their objection to the definition of qualifying communication in greater detail. Mr. Stoffel or Mr. DiDomenico, can either of you clarify a little bit where you're coming from on your objection to the definition of qualifying communication in 4407F? Go ahead, Mr. DiDomenico.
Your Honor, I think, can you hear me better, Your Honor?
Yes, that's much better.
Great. The intent of our comments there mainly were to point out that we would like to retain what Your Honor had drafted in terms of what is a qualifying communication. We also wanted to interject a little more clarity into the nuances around the language as far as when qualifying communication applies, which is when a customer calls to reconnect service, and the nuances whether or not that is same day or a day later. That was the intent from CNG's perspective, at least. I'll defer to Mr. Stoffel if he wants to add to that.
Thank you so much, Mr. DiDomenico. Mr. Stoffel, did you want to add to that?
Yeah, nothing really to add to that. I think we were just really trying to ensure that the intent in the original rules that Your Honor had drafted and proposed remained in place, while we also supported the clarification on this issue in the consensus rules. So we just wanted to make sure that as those two were merged, what you had presented through the draft rules was retained.
Okay, great. Thank you very much, Mr. Stoffel. Does anyone have any responses to DiDomenico and Mr. Stoffel's comments regarding the definition of qualifying communication? Mr. Denman and Mr. Bennett popped up at the same time. Mr. Denman, you're to my left, so I guess I'll go with you first. You go ahead.
Thank you, Your Honor. Based on my reading of the joint comments by CNG and Atmos, I did not understand that those two participants supported the clarification in the consensus rules, which appears on pages 1 and 2 of our pleading that was filed on July 18th. I'm not sure how to fit that in, but let me just say what I intended to say. there are two places that the term qualifying communication appears in this new statute. And the first may be in subsection 1.5 paren B paren Roman 1 of section 40-3-103.6. And that deals with reconnections. But the second place it appears is in 40-3-103.6 paren 3. And the latter, while the statute gives a definition, that definition applies beyond just reconnections. And if I could endeavor to read it, it says qualifying communication means one of the following methods of communicating with a utility customer about a possible upcoming disconnection of service. And then it lays out various ways. And in one of the subsections, the legislature said, or the customer receives the utility representative's text or email, because we have always believed that the use of the word receives was vague and ambiguous, and thereby possibly leading to arguments that that statute was unconstitutional. We thought it was a very good idea for in these rules of commission to define what receives means in the context of the definition and the use of qualifying communications. And so that's why that subsection F that we propose in the consensus rules is there. And we believe that even though the legislature didn't define receives, the commission's rules could eliminate that ambiguity and vagueness that I discussed. And so if, based on what Mr. Stoffel said, the participants at CNG and Atmos don't object to our definition of receives, I'm happy to hear it.
And if I can just respond to clarify that is consistent with our understanding that, you know, the clarifying or qualifying communication is specifically defined in the statute, but certainly needs some additional clarification to be implemented, I think, consistently across the board. And I think the concern that was raised in the Atmos and CNG comments was that it didn't get expanded into some broader requirement than how it is used in the statute. And that is specifically as an exception to the same day reconnection requirement.
Got it. Thanks so much, Mr. Stoffel. Mr. Bennett, you've had your camera on for a bit. Please go ahead and speak. I apologize for the delay.
No worries, Your Honor. Thank you. And again, I think this is another clarification in the way that Atmos and CNG are proposing this. As Mr. Stoffel said, a merger of your rules and consensus rules, that we make sure that they're not attempting to get the robo-dialers back in. I think it's pretty clear through the many discussions we've had that statute says you have to speak with an employee when you go through the phone, that, you know, in other meetings we said if you use the robo-dialer to connect a live operator to a customer, that's one thing, but the use of a robo-dialer in and of itself does not count. And I think you may have had that in the original rules, but through the course, I think we've gotten to that common understanding about the robo-dialers, with the exception, I think CNG and Atmos had discussed it last time, and to make sure that the language that they're just talking about in the merging is not to bring that term back in, because that's something that, again, EOC would oppose, and I believe UC, again, won't speak with them, but just from working with them.
Thank you, Mr. Bennett. And I'll be honest, as I read the proposals, I didn't interpret it to have included robocalls. So if I'm misinterpreting it and that was their intent, somebody please speak up and tell me, but I didn't read it that way. And I don't think that was my understanding, that was not their intent. So okay. Based on that, if my understanding is correct, then sounds kind of like we're all on the same page about that one.
Right. When I read it, that's what I was assuming, is we were trying to, you know, dial or go back to that previous version. But if it's as you interpret it, then I'm fine as well.
Okay. I mean, if there's something in there that I'm missing, please point it out to me. But as I read it, I don't think it says that. Am I missing something? Mr. DiDomenico, do you want to go ahead and speak?
Well, to be clear, we use automated calling. We think it works and has additional benefit, to communicate with our customers. So we have always recommended you retain automated calling. You had changed the rules previously to add automated calling, and we're recommending you retain the language that you had already drafted. That's our position.
Okay, so that's actually opposite of what Mr. Bennett wanted then. So Mr. Bennett, go ahead and speak. You've got your hand up.
Thank you, Your Honor. Yes, in that case, then we would oppose that change by them. It is quite clear in statute, and if the lawyers want to make the legal arguments on that, but from plain reading, when it says an employee, when you're going by phone, you must speak with an employee. I'll stand by my earlier statements that unless Atmos and C&G are proposing that robodialers are utility employees, which opens up a whole can of worms, I believe we're going to say AI or robots are employees, that does not comport with statute.
Okay, thank you so much, Mr. Bennett. Mr. DiDomenico, did you want to respond to Mr. Bennett? You've got your camera on.
I'm at this time not clear where exactly the word employees is used. Our understanding was the word was telephone call, and we believe an automated call is a telephone call. We can achieve the same result in our view as a text or email, which is also a qualified communication. To us, we can convey the same information through an automated call. To us, it's additionality, not a limiting factor. So our advocacy is to expand the toolkit to communicate with customers, not restrict it.
Okay. Thank you so much for that clarification, Mr. DiDomenico. Mr. Dixon, did you want to comment? You've turned your camera on.
I have more of a question. When Mr. DiDomenico says he's going to have an auto call made, which is going to provide some information, is that a qualifying communication whether or not the customer picks up the phone and just gets a voicemail? Or, as I think what Mr. Bennett's suggesting, using an automated call to get the customer, and then if the customer gets on the phone, provide that information, is what I'm hearing. I'm trying to draw a distinction or see if there is a distinction between what Mr. Bennett has said and Mr. DiDomenico is saying. So perhaps they can or Mr. DiDomenico for starts can clarify as to whether or not his point is he just leaves the message, whether or not the customer actually gets on the call.
Mr. DiDomenico, do you want to go ahead and speak?
Well, we're in favor of the definition of receives that's been offered, that we dialed the most recent phone number on file. To the extent that it goes to a voicemail or the customer picks up and listens to the message, the information that's conveyed that they may contact assistant agencies such as EOC, such as LEAP, also to contact the company itself for further information still is delivered.
Got it. Thank you so much, Mr. DiDomenico. Mr. Dixon, does that answer your question, or did you want to respond to Mr. DiDomenico?
I think Mr. DiDomenico is equating delivered with received, and we don't agree with that. We believe the customer actually has to receive. There has to be a means to know they received this information. And I suggested way back when, if you got a bad call, a number that it said this number's been disconnected, we know it wasn't received. If you send a text message and it says this did not go through, or an email, you know it wasn't received. So my point is not to as Mr. Bennett said, an auto dialer that then gets the customer on, who then hears the material from the employee, we know it's been received.
Okay. Thank you, Mr. Dixon. Does anybody else have any comments about that topic? Mr. Denman, I see your hand up. Please go ahead.
Yes, ma'am. Thank you. We believe that our definition of received in the consensus rules eliminates need for debate about robocallers. The statute doesn't talk about them. I agree with what, I'm gonna pull up my statute here. It's almost in the maze. It does say telephone call, text, or email, and the business about speaking directly with the customer, that subsection B of that statute and subsection C also says, or the customer receives the utility representative's text or email. We believe our definition of receives eliminates your need to tackle what seems to be a more contentious. And frankly, it seems to me if you were to insert into our consensus definition of receive some prohibition on robocalls, you go beyond what we've agreed to. So we would recommend you not do that. Thank you, Your Honor.
Thank you so much, Mr. Denman. Mr. Bennett, did you want to respond to Mr. Denman?
Yeah, I just wanted to thank you, Mr. Denman, for clarifications. I think where the confusion or the point of contention really arises is in that proposed rule that was issued that specifically said we can use robo-dialers. I think with consensus rules, in light of the rather clear language in statute about the customer speaking with the utility representative, that there's no need to really have that extra prohibition because it's clear. We've talked about receiving, statute talks about customers speaking with utility representatives if it's by phone. We have options of text and email. So from my perspective, it's rather clear. I think the rules that we worked on address the issues. Again, we've belabored this point, it seems like at every single meeting. And I thought we were on the same page, but it seems like we, in this last round of comments, went back to square one. So, to Mr. Denman, I know seems like we've worked through this, and I hate to go back to the beginning like you discussed, but between consensus rules and statute, I think we're there.
Thank you, Mr. Bennett. I appreciate your comments. Mr. Denman, do you want to respond to Mr. Bennett?
Yes, thank you, Mr. Bennett. We thought that it should have been resolved in our negotiation of the consensus rules. We stand by those consensus rules and thank Mr. Bennett for his recollection of those discussions.
Thank you, Mr. Denman. Appreciate it. Mr. Dixon, did you want to weigh in on that as well?
I just want to say, I want to make it clear, we support the consensus rules. Nothing I said was to suggest otherwise. So to the extent that may be implied, that's not my intent.
Okay. Thank you, Mr. Dixon. I appreciate that. Anybody else want to comment on the definition of qualifying communication? Okay. All right. If you give me just 1 second, let me make sure I'm in the right spot on my notes. Okay, the last point in Colorado Natural Gases and Atmos's joint comments was an objection to the inclusion of a requirement that utilities conduct at least one meeting with stakeholders and interested customers for education outreach and remote disconnection. I think Mr. Bennett touched on this briefly, but I just want to make sure we're all on the same page. And I do have 2 questions about Atmos's and Colorado Natural Gas's position. I guess, first of all, I wanted to know whether they are proposing that provision will be as they suggest for 44 and K to their language about ability of remote disconnection. Should the meeting required to be limited to utilities employing remote disconnection as well? Is that what you're asking for? Mr. Stoffel or Mr. DiDomenico?
That was for Atmos. That was our understanding that this education and outreach, multi-year strategy and reporting are all kind of together, and they should all really just apply to utilities employing remote disconnection.
Okay, thank you, Mr. Stoffel. Mr. DiDomenico, go ahead.
I agree. That's my understanding.
Okay, great. Now, let me, to my next point, Mr. Bennett touched on this, I think, which was already that they're not proposing, as I understand it, multiple meetings. So as Atmos and Colorado Natural Gas have pointed out, they're already required to conduct annual meetings with low-income stakeholders, and they're already doing that. As I read the proposals, and as I understand from Mr. Bennett's comments earlier, nothing I read indicated that the meetings can't be combined, that one meeting can cover all of those topics and address all those issues with the concerned stakeholders and customers. I just want to make sure that my understanding is correct, and there's nothing in anything that would require multiple meetings or separate meetings for all of these, and that there's nothing prohibiting holding one meeting to cover all of these issues. Go ahead, Mr. Bennett. Thank you.
Thank you. And apologies if you can hear the lawn maintenance outside.
I can't, so don't worry.
Okay, great, because it's really loud for me.
Sorry.
So from our perspective, no, there wouldn't be something requiring separate meetings. I think the intention was we already have these meetings going on in the interest of having better informed customers and consumers and better informed utilities, because imagine to be a two-way street, that we would combine these efforts and we could get this additional work completed. And we, again, as we discussed earlier, find value in having both gas and electric utilities do this, regardless of whether or not they're doing remote or traditional disconnections.
Thank you so much, Mr. Bennett. Anybody else have any comments about that? And I guess I would ask either Mr. DiDomenico or Mr. Stoffel to comment on Atmos's and Colorado Natural Gas's perspective. And are you still objecting if everyone's understanding is that one combined meeting is acceptable? Mr. Stoffel?
So I think the critical issue is this isn't just having these meetings, it ties in with the multi-year strategy and reporting. And so there's follow-up requirements tied to this specific meeting requirement. I think I'd ask the inverse question: when we already have an existing requirement to meet annually to raise any issues of concern to these stakeholders, why do we need a separate specific requirement that could be covered in that same meeting if disconnection and reconnection are an issue they want to raise in that existing meeting? So I think our concern is not only having it as a standalone requirement, but also the conditional requirements attached to it, or the additional requirements that are attached to that meeting, and just lead to what is additional regulatory burden for, as we've talked about, utilities that are going to continue to try to prevent disconnection. As has been a theme throughout this whole case, disconnection is not an objective of any of the utilities. And so it's just layering in additional regulatory burden that really doesn't seem necessary for utilities that are not changing the technology used to conduct disconnection and reconnection.
Let me just ask you this, though. If it's just a point that needs to be made at the meeting that's already has to happen, is that still overly burdensome, though? If it's just,
Well,
you got 5 points, you have to make 6 now.
And my point is, it's not just the meeting. It's also tied to the multi-year reporting strategy that we're also objecting to, right? So I think you have to look at those together.
Okay. Thank you, Mr. Stoffel. I appreciate it. Mr. Bennett, you've got your camera on. Please go ahead.
Thank you, Your Honor. Again, I reiterate our point that we believe that there is it's worthwhile to have these meetings and the strategy reporting and the strategies out in the open, so that not only consumers know what's going on, but consumer advocates such as EOC, the commission, who has expressed a lot of interest lately in disconnections and the impact that disconnections have on families, that everyone knows what's going on. There is a lot of expertise in the state, and if we are all operating with black box operations, it's pretty hard to improve and find out what others are doing that maybe we should adapt, or maybe there's something that should become more widespread policy. So it's not just for the benefit of, work to do work. This is important work so that we all know what's going on, we can learn from each other. And like Mr. Stoffel said, they're not in the business of doing disconnections. And this is something that we do not believe is very overly burdensome and has a lot of upside and benefit for consumers, the advocates that are operating in the space, and the commission that has an interest in making sure that customers are educated, informed about what's going on, and not being disconnected in how to get access to resources. You know, over the past few years, we've had multiple pieces of legislation addressing consumer rights and consumer protections and referral to resources. We've had additional legislation to provide extra funds to resources. So this is all a concerted effort, and having something out there for all of us to see and make sure that we are working together on this is much more important, I think, than not wanting to file one report as being overly burdensome, as you implied. If it's just a fifth or sixth question in one meeting, I don't see how not asking that question and not filing that multi-year report, which again is not very burdensome on the utilities in light of what they're doing already. And that's literally just stating what you're doing, why that would be so difficult that we would not do it in light of all of the upsides.
Thank you so much, Mr. Bennett. Does anybody wish to respond to Mr. Bennett's comments? Mr. DiDomenico, please go ahead.
Yeah, Your Honor, I think, our perspective is no one wants black box processes, but it's been in the rules for years and years how we communicate with customers. We just went through a proceeding, 23M-0042EG. I'd recommend Your Honor take administrative notice of that, because it was a detailed look at disconnection reporting by the commission itself. And we were working with the advisory staff to improve our reporting. We took several steps to do that. I don't think the idea that anything is a black box is accurate. We've always been communicative about our processes, willing to discuss them. We file reports about disconnections. We follow the procedures in the rules. Some rules aren't even being an issue in this proceeding, such as medical certificates. There's ways for customers to avoid disconnections that we haven't even discussed. So I just want to raise the full universe of what has been communicated. And every time rules change, we file an advice letter. We advise customers through notice. We don't just do it blindly where they don't get notice. They receive notice of changes. Just wanted to point that out.
Thank you so much, Mr. DiDomenico. If I could ask you, I want to make sure I had the proceeding number right. Was it 23M-0042EG, the one you're referring to?
That's correct, Your Honor.
Okay, that was referenced in your comments, and I just wanted to make sure I had it correct so that I can find it and read it.
Thank you.
Thank you, Mr. DiDomenico. Mr. Dixon, you've got your camera on. Would you like to go ahead?
Yeah, well, I don't dispute what Mr. DiDomenico said. They've been doing all this for historically, it's been in the rules. We have a new statute. We have new rules. So it's not what you've done in the past and complying with those rules. You have a new rule and a new statute. And I'll take the liberty. I just pulled up Colorado Natural Gas's question on how will my service be restored. I will read it into the record. When you will need to contact our customer service center at 800-720-8193 to schedule a time for your service to be restored. Once you have paid your past due amount or entered into a payment agreement, C&J will reconnect your service within 24 hours, excluding weekends and holidays, or within 12 hours if customer pays after hours. Then it goes on to say, how much will it cost to restore my bill? The amount your service was disconnected for and any amount for which it has since become more than 30 days past due, a collection trip charge of $43 when service was disconnected for the non-payment, and restore service charge of $43 per service call. Your account may be charged a deposit up to 90 days estimated gas usage at that address. That does not reflect the current law on reconnection, pure and simple. I have searched their website to see where I could find it. The point I'm getting at, this is me I have a modicum of knowledge of how to search websites for utilities. I don't know if an average consumer would be able to figure out what the new law has said and how that new law is being implemented. And so our whole customer education process is to bring that to the attention to the customers in advance of finding themselves in this circumstance, so to speak. When you finally lose that one last paycheck and you're now in big trouble, you should have some knowledge in advance of what you got to deal with. And that's all we're talking about. It's not about the fact that the utilities have done this in the past. They haven't done what the new law requires in the past. And I'm not arguing about the quality of what they've done in the past based on prior rules and statutes.
Thank you so much, Mr. Dixon. I appreciate that. Mr. Stoffel, you've got your hand up. Would you like to go ahead and speak?
Yes, thank you. I just wanted to make sure the record's clear that the new law requires implementing regulations. It requires the commission to implement rules adopting these standards for disconnection and reconnection. It is not self-effectuating. These are not effective as we sit here today. And so that, given what Mr. Dixon said about CNG's practices, I just wanted to make sure that it's clear that these rules have not been adopted to implement the statute.
Thank you so much, Mr. Stoffel. Mr. Denman, you've got your hand up, and Mr. DiDomenico, you turned on your camera. I think Mr. DiDomenico had his camera on first. So Mr. Denman, if you could just hold on for 1 minute and let Mr. DiDomenico speak. Go ahead.
Certainly.
And I'll be pretty brief, Your Honor. CNG has every intention, once Your Honor issues a decision in this proceeding, to update its website and its tariffs. We are fully cognizant of that requirement, and we'll notify our customers when we do so. Thank you.
Thank you, Mr. DiDomenico. Mr. Denman, please go ahead.
Thank you, Your Honor. More of an administrative process comment. Mr. DiDomenico asked you to take administrative notice of proceeding 23M-042EG. I have reviewed the Commission's e-filing proceeding detail page for that. There are a lot of documents in that proceeding, and I thought perhaps to assist you with making sure the record is clearer, he might tell you what exactly in that proceeding you should take administrative notice of. There are a lot of monthly reports and other pleadings, for example, filed in that. It appeared to me that he was interested in the major decisions that the Commission reached in that proceeding, which were cited in the joint comments by CNG and Atmos. But I just suggest he clarify what he's asking you to take administrative notice of. Thank you.
Thank you, Mr. Denman. That is good advice, and I really appreciate it. My assumption, perhaps incorrectly, was that Mr. DiDomenico is referring to the two decisions that are referenced in the joint comments. Those are decision numbers C23-0240 and C23-0361. Mr. DiDomenico, if you could just let me know, was there anything else in the file for proceeding number 23M-0042EG that you wanted me to take judicial notice of? Please tell me. Otherwise, I'm going to assume it's just those two decisions.
Your Honor, I would recommend, and I don't know if this was attached in any decision, but there were final report formats that were, and they are on the Commission's website.
Final report formats
for the disconnect annual report. Let me be clear.
Okay. Okay. Make a note of that.
Your Honor, if it helps, the attachment A to decision C23-0096 is a monthly report form. I don't know if there were others, but I know that decision at least had that attachment. Maybe that.
Okay. Got it. Thank you, Mr. Denman. Appreciate it. Anyone else have any comments about that issue and that topic? Okay. I want to then open it up. Does anyone else have any points raised? Topics they will discuss regarding consensus rules on July 18, 2020? Because they were just literally minutes before that last public comment hearing, it was difficult to discuss them in great detail at that hearing. So if there's any points regarding that proposed consensus rule that anyone wants to discuss, please bring them up now. Thank you. Anyone? Okay, no one else has any comments or statements they want to make about the proposed consensus rules? Mr. Dixon, do you want to say something? Go ahead.
Well, I just think it's important to note the proposed consensus rules were agreed to by two utilities, rather large utilities that operate both gas and electric service. This is a customer education issue. It isn't really, as I've said over and over again, it's not about remote disconnections. And I take full responsibility that the UCA brought up this issue in an effort to prohibit remote disconnections. We backed away from that and have since focused on the broad nature of what the statute addressed. We recognize the statute itself had no comment on the validity of remote disconnections one way or another. So we have focused on what it started at, about disconnections and reconnections for all services, no matter how it's done. And so that's the purpose we have. So we have two major utilities who agree. Now, CNG and Atmos like to present the fact that they're rather small compared to public service, but they're not small companies. I mean, these companies have operations in other states. Atmos is a great large company. So just because and by the way, its customer count in Colorado is not unlike that of Black Hills for its gas side. It's not identical, but it's similar. But this whole idea that they're too small to tell their customers what's going on just doesn't hold any water. Customers are customers regardless of the size of the utility, and these rules apply, these statutes apply. And I find it interesting to say these are self-effectuating because it's my understanding, and again, reading the very language on CNG's tariffs, it contains the prohibitions that are contained in the statute, which according to Mr. Stoffel is not self-effectuating. So I have some issue with that. The statute says what the statute says. And so to the fact, I guess we're saying, what I'm hearing Mr. Stoffel say is don't pay attention to the statute until you issue rules and they're finally approved. I have some problem with that legal argument. I'll leave it at that.
Your Honor, if I may respond.
Sorry. Of course, Mr. Stoffel.
It was not created new, it was amended. And the rules already address disconnection, as Mr. DiDomenico said earlier. So there are already requirements in place in the rules that were in place before the statute, before it was amended, that the utilities are complying with. And now we're talking about amending the current rules to reflect the amendment to the statute. And so it's the new requirements around same-day reconnection and quote, the exception for qualified communications are new. And that's what we're talking about here. And that's what, until it is adopted into effective rules, do not apply. But I'm not saying that there are no restrictions or prohibitions around disconnection. We're just evolving as the law around those issues have evolved.
Thank you for that explanation, Mr. Stoffel. Does anybody have any response or any comment they'd like to make in response to Mr. Stoffel or Mr. Dixon? No? Okay. All right. Any other points anyone or topics or comments anyone would like to make about the joint response filed by Atmos and Colorado Natural Gas? Anything else anybody wants to say about that? All right. Let me just ask generally the few topics that we've been talking about and have come up repeatedly, even in this hearing, the issues of robocalls and qualified communications and the use of the advice letter proceedings. Does anybody have anything else they want to add about those topics? No? Okay. I appreciate all your feedback on those specific discrete issues. And I'll now open the floor to any additional topic or comments anyone wants to make about the rulemaking process generally and the proposed rules generally. Does anyone have any other topics, comments they would like to make about just the proposed rules in general? No? Okay. Okay, last call. Anybody have any additional comments that anyone would like to make, or any topics anyone wants to discuss before we close the public comment portion of this hearing? Okay. It looks as if no one has any additional comments, so I think we have come to the conclusion of the comment portion of this public comment hearing. I want to thank you all for your comments regarding the proposed modifications to the rules governing the disconnection of gas and electric service. At this time, it appears that no one has any additional comments to offer, and that we've come to the conclusion of today's public comment discussion. Now, my inclination at this point, because it appears that we've discussed these topics quite thoroughly over several public comment hearings, and that many issues have been resolved between the various stakeholders to these rules, and regarding some of the contentious issues concerning the proposed gas and electric rules. It is my belief that any further discussion is not necessary or warranted, and I'm inclined to not continue the public comment hearing again, that this would be our concluding public comment hearing on this issue. I guess I would ask if anyone objects and has a belief or a need to have one more public comment hearing. I'm willing, but at this point, my inclination is to close the hearing portion of this proceeding at this time. Mr. Denman.
Your
And
Honor.
Mr. Dixon, I would very much appreciate your perspective on this.
Thank you, Your Honor. We agree with you that you have thoroughly
Beaten a dead horse.
you thoroughly solicited, and we participants have thoroughly provided you with a robust record in this proceeding, and we agree with you that there's no need for another continued rulemaking hearing in this proceeding. And we thank you very much for your patience and consideration of our written comments, and particularly the consensus rules that we tendered with our colleagues.
Well, I honestly appreciate all of your comments. I very much appreciate the consensus rules that I know all the interested stakeholders worked so hard to hash out, and it honestly makes my job in many ways much easier. Mr. Dixon, please go ahead.
First of all, I agree completely with Mr. Denman. I think this has been come down to two major topics. You got a set of consensus rules and you have an objection. And I think that's where this case resides. I don't want to write any more comments. I don't want to talk about it anymore. I want to see what you have.
I do love reading your comments, though,
Pardon?
Mr. Dixon. I do love reading your comments, though.
No, thank you. But my point is, I'm looking forward to your ruling one way or another. And, the big thing we need now is a decision, and I would appreciate that at your convenience.
Okay, thank you so much, Mr. Dixon. All right, then I will go ahead and we'll be closing the public comment hearing portion of this proceeding. Although the hearing portion will be closing, I just want to make clear that interested persons or stakeholders are still free to submit additional written comments or leave a verbal comment on the Commission's voicemail, because there is no deadline for submitting comments, and comments in written or voice form will be accepted by the Commission until this meeting is closed. And let me make clear that we're closing the hearing portion, but not the proceeding itself. We just won't be having another public comment hearing at which oral comments will be taken. As I indicated at the beginning of the hearing, all written comments will be added to the record of this proceeding, and all verbal messages left with the Commission regarding the gas and electric rules will be transcribed and filed in the record of this proceeding as well. Mr. Dixon, please go ahead.
I was just going to say, I would hope we have an agreement between the utilities, that is Public Service, Black Hills Electric, Black Hills Gas, Colorado Natural Gas, and Atmos, as well as the Energy Outreach Colorado, and the Utility Consumer Advocate, that we will not file more written comments to have this continue on, that really what you're talking about, although we are entitled to, so I don't want to suggest we can't, But what I think you're getting at is the public would be able to file comments, or any other party that even hasn't been involved, because that's what the statute on rulemaking allows. But I will represent to you that UCA has no intention of putting in any more comments. We've said what we need to say, and they're in there. And we, again, appreciate all your efforts in listening to all the comments that have been filed. So I just hope that the utilities and the players, EOC and UCA, can agree. We have no intention of filing more comments.
Thank you so much, Mr. Dixon. I do appreciate that very much. But as you indicated, I wanted to make sure that the public at large and any interested stakeholders understand that although the hearing portion is closed, comments can continue to be accepted. I would find any wishing to submit any further comments, please ensure their voicemail message or written comment includes the proceeding number, which is 22R-0557EG. Let me say that again, since I didn't say it clearly. 22R-0557EG. I would caution anyone, though, that anyone who does decide to submit additional comments after the closing of this hearing portion, that although I don't know when my decision will issue, it's my hope that it will be within the next 30 to 45 days. And therefore, if anyone has an intention of filing any additional written comments or leaving an additional voicemail message comment, that you please do so within the next 2 weeks or so that I have an opportunity to review those before I draft the decision. That then brings this public comment hearing in proceeding number 22R-0557EG to a close. Again, I want to thank all of you for participating. I want to thank everyone for their thoughtful and thorough and helpful comments. I think we had a very productive conversation and a productive discussion on how these rules are going to play out. And I truly appreciate all of your work and cooperation in getting to this point. We are adjourned, and the hearing portion of this rulemaking proceeding number 22R-0557EG is now closed. Thanks very much, and have a good afternoon and a good weekend, everyone.
Thank you, Your Honor.
Thank you, Mr. Denman.
Thank you.
Thank you,
Thank you,
Mr.
Your Honor.
Stoffel. Thank you.
Thank you, Your Honor. Have a good weekend.
You too, Mr. Dixon.